cases. Mark, you're on.
Thank you.
We are on. The more recent cases that have come out of both federal and state courts concerning computer technology and the internet. We've chosen the last 2 years as the time period from which to pick these cases. We have some very distinguished panelists. I'd like to introduce them to you. First, my name is Andrew Grosso. I'm the moderator. So I will try and pick and choose the best questions to go to the best panelists, but they are all free to chime in as they wish. The panelists are, to my far right, Bernice Donald, who is a circuit. Bear with me. Mark, you've just been covered up. There we go. There we go. Bernice Donald, who is the Honorable Bernice Donald. She is a U.S. Circuit Judge for the United States Court of Appeals for the Sixth Circuit. She was appointed by President Obama and confirmed by the Senate in 2011. Previously, she served for 15 years as a district court judge for the United States District Court for the Western District of Tennessee. Before that, she was a bankruptcy judge for nearly 8 years and a Tennessee state court judge for 6 years. She has served as chair of the ABA's Criminal Justice Section and is a recipient of the ABA's Margaret Brent Women's Lawyers of Achievement Award, recognizing women who are lawyers and who have excelled in their field and who have paved the way to success for other women lawyers. Thank you very, very much for participating today.
Thank you, and that luncheon this year will be Sunday at noon in this hotel.
To my far left is Alan Butler. He is Senior Counsel of the Electronic Privacy Information Center, otherwise known as EPIC, in Washington, D.C. He manages EPIC's litigation, including its amicus program, and files briefs in privacy and civil liberties cases before the U.S. Supreme Court and other appellate courts. Among the briefs that Mr. Butler has authored on behalf of EPIC is an amicus in Riley against California that was cited in the Supreme Court's unanimous opinion upholding Fourth Amendment protections for cell phones. He has also authored briefs in national security, open government, workplace privacy, and consumer privacy issues. Mr. Butler is also chair of the Privacy and Information Protection Committee of the American Bar Association section on civil rights and social justice. To my immediate left is Professor Lorraine Kisselbrew, formerly of Purdue University, where she was Professor of Media, Technology, and Society, a faculty fellow with the Center for Research and Education on Information Security, and a lecturer in the Center for Entrepreneurship, also at Purdue. She spent 20 years as Chief Information Officer for a large college before moving into academia. Her research focuses on privacy, security, and ethics in emerging technology contexts and how people interact and collaborate in technological settings. Her research has been published broadly and has been funded by the National Science Foundation and the Department of Homeland Security. Currently, she serves as a member of the Executive Committee of the U.S. Technology Policy Committee at the Association for Computing Machinery, which, for those who may not know it, is the equivalent for computer professionals of what the ABA is for attorneys. This fall, she will be a scholar in residence at the Electronic Privacy Information Center. I didn't know this when I asked her to speak, so this was not some nefarious plan. Now, sitting in the center of the room, smiling from his home in Bethesda, Maryland, is Mark D. Rash. He is both a cyber lawyer and a cyber evangelist, and I'm not quite sure what that latter term means, but he uses it. He is in private practice in the Washington, D.C. area. Earlier in his career, Mr. Rash was a trial attorney with the U.S. Department of Justice, where he led the department's early efforts to investigate and prosecute cyber and high technology crime. He started the computer crime unit within the Civil Criminal Division's fraud section and was responsible for various high-profile computer crime investigations and prosecutions, including the very first prosecution brought under the Computer Fraud and Abuse Act against Robert Tappan Morris. Mark has been a frequent commentator in the media on issues related to information security, appearing on BBC, CBC, Fox News, CNN, NBC News, ABC News, the New York Times, the Wall Street Journal, and many other outlets. I guess that's what it means to be a cyber evangelist. Thank you, Mark.
Thank you, Andy.
And I will say that the reason Mark is appearing by Skype is that one of our panelists, Dennis Reardon, was at the last moment unable to come, and Mr. Rash graciously agreed to participate. Today is his birthday, however, and his wife is planning a big party, so he couldn't make it out here in person, so he's on the screen. Thank you very much. We're going to go through a number of cases. We picked out 7. We'll go through them as quickly as we can. Well, I take that back, as thoroughly as we can. And the first one is going to be Carpenter, United States against Carpenter. Then we're going to go into the state court with the United States against Loomis out of Wisconsin. Carpenter is, of course, the recent Supreme Court case that concerns cell phone technology. Loomis concerns algorithms used in sentencing. United States against Nozzle, concerning the proper interpretation of the Computer Fraud and Abuse Act. We'll have some Bitcoin cases, and we'll have some personal privacy cases, leading off with Spokio in the U.S. Supreme Court. So I'm going to turn the panel over right now to Lorraine Kisselbrew and ask her if she could explain some of the technology we're going to encounter today. And I put up on the screen a PowerPoint that lists some of these items, and I have 2 of those PowerPoint with technological terms. Lorraine?
Hi, can everybody hear me in the back? Yes? Okay, I'm not going to spend very much time on these terms, and since one of the slides has been up there for a while, you've probably had a chance to read and review them. Really what I want to do is tee up an understanding of these cyber cases, which of course are based upon technology, which is familiar to some of you in some cases, but in others it may not be. So very, very quickly, I'd like to just introduce these terms, and then I will reiterate them later on when we're discussing the cases. First and foremost, if you're dealing with any kind of privacy law, it's important to understand the definition of what is personally identifiable information. And essentially, PII, personally identifiable information, is anything that has the capability to uniquely identify an individual. And that can be a singular form of identification. It can be in combination. So we typically think about national identification, social security number in the United States, street addresses, driver's license numbers, phone numbers, IP addresses, email addresses, one's age, gender, demographic information, as well as biometric data, which we will talk about a little bit today. So that's our general sense of what constitutes data which is considered personally identifiable. Global positioning system. Most of you by now have heard of GPS and its capabilities to locate individuals or devices or buildings and so forth. So essentially, this is based upon satellite navigation coordinates, and you're able to precisely identify. I don't know if there's anybody in the audience who hasn't yet used their smartphone to navigate 2 blocks down and know whether to turn right or left and where you are. So it's a very handy navigational tool, but has implications for what it reveals about one's location. Metadata is something that we hear about a lot, and it's written about in many of the cases, but it's not necessarily very well defined. Metadata is, in essence, data about the data. And typically what the best example that I can think of is when we talk about telephone record metadata. The metadata is actually describes the content of the record, but it doesn't include the content of the telephone call. So you had the number that was called, how long the conversation took place, and these kinds of things. That's one example of a metadata header for a record about a telephone conversation. In the Carpenter case, we're going to be talking about CSLI, which is cell site location information. And essentially, it is precise information, time-stamped information, so time and space-stamped, if you will, information about when a device was transmitting to a cell tower. Triangulation is also something that we'll talk about in Carpenter because essentially the process of triangulation has become more sophisticated. With more cell towers, it allows you to be more precise in terms of identifying not just a spectrum of a half a mile on where an individual might be, but perhaps within 50 meters. So that triangulation process essentially means we have multiple data points in which a device pings to those towers, and from there, we're able to map out an area in which that device is located. It may be to the right of it, maybe to the left of it, but generally we know the area in which that device or individual is located. An algorithm is something, as a computer scientist, we talk about algorithms all the time and we make the assumption that people know what they are, but essentially an algorithm very generically is a set of instructions that do something. So in a computer programming language, the algorithm is the logical structure that determines what's going to happen, what's going to take place. In math, it can be an order of operations in an equation, but essentially it's a logical structure of instructions or operations that are performed on something. In Loomis, we're going to talk about algorithms a little bit more. We're going to talk about what these algorithms do in that particular case. And essentially, they're predicting the risk of someone re-offending in the crime. And so we're going to talk about statistics as much as we are going to talk about the technology in terms of how accurate these predictive tools can be, how reliable they might be, and what their validity is. And validity means is what's being measured actually relevant and salient to what we're trying to predict. So I may have a fantastic tool, but in fact, it is measuring something quite different than the object that I want to measure, which is how often or what's the risk at which somebody is going to commit an additional crime. So we'll talk a little bit about that. Just a second, I'm moving from a Mac to a PC, so, and I should be savvy, I'm out of practice. Okay, a few more, and I'll try to be a little bit quicker on this. We're going to talk about biometrics, and biometrics essentially is a way of measuring something with biological properties. So rather than a number, a social security number or a telephone number, it may be someone's DNA, it may be someone's genetic material, it can be a fingerprint, something that everybody is familiar with. It can be a scan of the retina and the iris. It can be a vocal print, the unique properties and signals that are contained within the voice. And in the case of this Santana case, what we're talking about is facial recognition scanning. And so having the multiple data points that are scanned, how accurate is that identification, how sensitive is that identification in terms of concerns about being protected. An avatar. An avatar is pretty commonly known now because popular culture has made it represented in films and so forth. But an avatar essentially is a virtual representation of someone. So it may have a very close connection to the real individual who is being represented on there. Oftentimes it's not quite clearly represented, and sometimes it may actually serve as something that has no connection with the physical properties of the individual who is using that particular avatar. So we'll talk a little bit more about that. And then favorite topics is we're going to talk about Bitcoin and blockchain and some of the terms attached to that, including cryptocurrency, which very simply is an electronic form of currency. Bitcoin is a form of cryptocurrency. Blockchain is the technology platform upon which Bitcoin transactions take place. And blockchain, very simply, is a chained, sequential, chronologically ordered set of pages. And in the case of Bitcoin, the page or the block is a list of transactions that have been made. And so if you can imagine filling up your ledger page with a list of financial transactions, and when you get to the end of that page, it has to go somewhere. It doesn't stay in the book. It gets submitted to the block, to the chain. And so we're going to talk a little bit more about that, including encryption and hashing. So that's my introduction and my start.
Thank you very much. We're going to go to the Carpenter case. And very briefly, Carpenter is a Supreme Court case that came down with a 5-4 decision affecting Fourth Amendment law. The facts, very briefly, a gentleman was arrested for a large number of robberies, and the police used cell phone tower information that tracked his cell phone in order to buttress their argument that he was indeed involved in this criminal activity. I'm going to turn over the analysis of the case to Alan.
So as Andrew mentioned, Carpenter involves the tracking of a cell phone, and as Lorraine laid out, that specific method of tracking is the collection, the access to these cell site location information records that are held by the phone company. In this case, the phone companies were Metro PCS and Sprint. And I'll just start the discussion of Carpenter by noting that it's really hard to underestimate the significance of this decision, especially for a panel like this one, where we have folks coming from the criminal justice section of the ABA, myself from the privacy section of the section on civil rights and social justice. This case is at the core of both of those areas, and I do think that in the years ahead, people will may look back on Fourth Amendment cases as being really before Carpenter, after Carpenter. This case is really that significant for the Fourth Amendment, and the reason is because even although Chief Justice Roberts attempts at various points to portray this as a narrow decision, I think the logic of the decision in this case in favor of the defendant is quite broad. And will have wide-ranging applications going forward in the Fourth Amendment because of the nature of law enforcement investigations and the tools that are being used. And I think this is underscored by the fact that, as Andrew mentioned, this was a 5-4 decision, but unlike most 5-4 decisions, there were actually 4 separate dissenting opinions written in this case. One by Justice Kennedy, one by Justice Thomas, one by Justice Alito, and an opinion by Justice Gorsuch that we'll talk about that really is more of a concurrence than a dissent. But albeit all 4 of them wrote separately and wrote lengthy opinions, 20-plus page opinions. I think most of them were actually longer than the majority opinion. So there's a lot of controversy drummed up by this case, and I'll kind of explain, I'll walk you through it and explain why. We've already mentioned this case involves the collection of information about cell phones. To be precise, the defendant in this case had 6 months of location records collected by the investigators, 12,898 location points, an average of 101 data points per day about this individual. The cell phone essentially acts as a sophisticated tracking device, most modern cell phones that we're all carrying around with us. And this is because in order to route a call, the phone company has to know where you are. They have to know the closest tower so that they can send an incoming message or call to that tower. And because of that, your phone is constantly basically playing a game of Marco Polo with the towers around it. It's pinging and saying, I'm here, where's the tower, I'm here, and finding the closest tower. And those pings, as well as the connection records when a call or message is completed, create data that's collected by the phone company and stored, depending on the phone company's policies, for months, years, in most cases years. And these are the records that law enforcement are increasingly trying to get access to in the course of investigations to prove movement, location, relationships, etc. And the way they do this pre-Carpenter was by using a provision of the Stored Communications Act, which was part of the Electronic Communications Act of 1986. This is 18 U.S.C. Section 2703D. This is a provision that authorizes a court to issue an order. The order is based on reasonable grounds to believe that the records are relevant and material to an ongoing investigation. So it's not a warrant. It doesn't require probable cause. It doesn't even require that the target be a suspect. The target could be a witness. It could be anybody. But it is a court order. And once that court order is issued, the carrier, in this case Sprint and Metro PCS, are required to disclose that information to the police. This statute, it's worth noting, was passed in 1986 before cell phones as we know them exist. The purpose of the statute was not to authorize law enforcement to obtain location data. And in fact, law enforcement really didn't begin seeking this type of data in earnest until at least the late 90s. But it's grown since then, and in the 2000s there were a number of prominent cases involving applications that were heavily litigated around obtaining location data. And in particular, there was a big disagreement among the prosecutors in the court and the magistrate judges over obtaining real-time location data. Because although the Stored Communications Act appears to authorize the collection of subscriber records that would include location data, does not, since it is the Stored Communications Act, actually authorized real-time tracking. The DOJ developed what is called the hybrid theory of combining a Stored Communications Act order with a pen register order to give them kind of a magic sauce that would get both historical and real-time records. And there were a number of magistrate judges who rejected that theory and what some have called the magistrates' revolt in the mid-2000s. So there were a number
They
of
also created an illusory thing called prospective historical records.
Exactly.
Which are records that are going to be created in the future, but after they're created in the future, they will be historical records, so they're not real time.
Exactly. And so much of the focus at that time was on this distinction between historical and real-time records because it was a statutory fight. There was ultimately a decision in the Third Circuit that held that a magistrate judge has the discretion to require a warrant to obtain real-time location data, but it's not required under the statute. But the Fifth Circuit upheld the use of the hybrid theory. So this was all going on in the mid-2000s. And amidst that, yet we still didn't really know how pervasive this technique was, because the wiretap, which requires detailed reporting of how frequently wiretaps are used to obtain real-time communications, there's no similar reporting on the use of D-orders or the collection of location data. So there's some reports created by companies, but these reports are not in any way comprehensive, and they're not compiled by the Administrative Office of the U.S. courts. So in this case, Carpenter argued that the use of the D order and the collection of his location data violated his rights under the Fourth Amendment. The government argued that it did not, because under Smith versus Maryland, the 1978 case, the collection of non-content metadata records from a phone company is not a search. The Sixth Circuit ultimately agreed with the government, and as had up until that point every other federal circuit that considered it, although I'll note that in the 11th Circuit and the Fourth Circuit, three-judge panels had rejected that theory on different grounds, so those were overturned. So when the Supreme Court agreed to take the case, all the federal circuit courts agreed that Smith versus Maryland controlled it wasn't a Fourth Amendment search. So that raised the obvious question, why did they grant cert, right? The Supreme Court almost always grants cert to reverse. They typically don't grant cert to affirm when there's unanimity below. And so really it was, I would say, the culmination of a decades-long process of developing what I call a digital Fourth Amendment, a new theory about how the Fourth Amendment applies to new technologies. You can trace this all the way back to the 2001 decision in Kylo, which was a case about the use of a thermal imaging device to monitor and collect information about what was going on inside a home. But certainly was in full force in 2012 when the court ruled in the Jones case, which was about the tracking of a car using a GPS device attached to the bottom of the car. There you had a unanimous outcome, but a split in logic. So all 9 judges agreed that the attachment of a GPS device and the tracking of a car for 28 days was a search under the Fourth Amendment, but they disagreed about why. You had Justice Scalia write a majority opinion joined by Justice Kennedy, Thomas, Roberts, and Sotomayor, finding that the attachment of that device, the physical trespass, triggered the Fourth Amendment regardless of whether any sort of reasonable expectation of privacy was invaded. Justice Alito with the others arguing that under the reasonable expectation of privacy test, the traditional CATS test, monitoring a car's movements for 28 days was a search. Justice Sotomayor kind of bridged the gap there.
Alan, I just wanted to interject and say that in looking at the case, it is very clear that the court was taking note of how rapidly things had changed. And in a lot of these Fourth Amendment cases, courts could look at the conduct, and that conduct could be readily assigned to a category, a class of people who are not going to be normally affected by or even need this protection of the 14th Amendment, even though it is for everybody. But I think the fact that Chief Justice Roberts opened this case by noting the ubiquity of the cell phone, he says that there are 396 cell phone service accounts in the U.S. and 326 million people, and so he's basically saying now, this is activity that where everybody pretty much is affected, and I think he was really cognizant of how much, I guess, privacy expectations maybe had evolved, changed, grown, and that it struck me when I looked at the case that starting off with that, just put it all in context.
He really, yeah, that's absolutely right. Justice Roberts really starts off in the Carpenter decision by pointing out this ubiquity, as you say, and thinking back to Jones, it was funny because the attorneys for the government, I think, knew the case was lost when Justice Roberts asked them if they could track his car everywhere he goes without a warrant. And at that point, I think the government's lawyer didn't feel so great about his odds. But I think that this theory of ubiquity, the change in digital technology that has driven this sort of evolution of the Fourth Amendment really came to a head in the Riley case in 2013, where Justice Roberts wrote a unanimous majority opinion there. That was a case involving the search of a cell phone incident to arrest. The traditional rule was that if you're arrested, you can be searched, everything on your person. And what the court said there is not your cell phone. They can search your pockets, they can look at physical items, but they can't open your phone up, analyze it, review the files, copy the data. And for this exact reason, Justice Roberts said, look, we all have cell phones. The nature of these devices is just so fundamentally different from the physical analogs that the physical rules don't make sense. They don't apply here. And the same happened in Carpenter. You have Justice Roberts, again writing for the majority, here a narrower majority, essentially saying that even if we had traditional rules under Smith versus Maryland, which was about phone call records, or Miller versus United States, which was about bank check records, even if those traditional rules applied what many refer to as the third-party doctrine, an exception to the Fourth Amendment, that doesn't make sense in the context of cell phone and a particular cell phone location data because so much has changed. We all carry cell phones with us everywhere we go. In that sense, it's more of a catalog of our behaviors and movements than would be a record of where we drive. Not everyone has a car. Everyone has a cell phone. There's actually more cell phones in the United States than there are people.
The other thing they had to overcome is a holding in 1983 in the Knott's case, where the government had put a beeper into a precursor chemical bottle and sold it to somebody and tracked the beeper where the person was driving. And one of the things the Supreme Court held in Knott's was that people have no legitimate expectation of privacy in their physical location where it's capable of being seen without an invasion of privacy. So when you're driving around the streets of Chicago, you run the risk of being seen. So one of the differences between Knott's and Carpenter is this whole idea that the volume of data that can be collected, and this is reflected in the Riley decision as well, the volume of data that's being collected and the ability to analyze that data and track many people changes the character of the data and changes your expectations of privacy in that data.
Exactly. I think the interesting thing about Knott's that was noted in Jones and then again in Carpenter is that, the court kind of specifically laid down a marker, even in the 1980s, where it said, look, the defendant in that case had essentially argued, if you allow my car to be tracked down a highway using a radio beeper, then this is dragnet, and the police can track me wherever I go. And the court in the 1980s said, well, wait, we're not there yet. This isn't dragnet surveillance. We're just talking about an individual being tailed by an individual police officer with a radio beeper. Fast forward to Carpenter, and it's exactly what we're talking about. Everyone has a cell phone. These records are recorded as a matter of course, and as the court points out, when they have to distinguish Miller and Smith, those cases had relied on a theory that individuals assumed the risk, that if they told the bank about a transaction, or if they called a phone number using a phone system, they assumed the risk that could be disclosed. And Justice Roberts essentially says that's not what's happening here. There's no sort of consent or assumption of risk. It is just incident to the delivery of a service that has become all but essential in the United States.
Alan, I want to jump ahead a little bit and make a statement. I agree with you that we're going to look at the Fourth Amendment and say there's pre-Carpenter and post-Carpenter. And there are two statements by Justice Roberts in the opinion that I think make that clear. The first is that he says that there is a, quote, legitimate privacy interest in records held by a third party. I have never seen anything like that come out of the courts before on Fourth Amendment law. The other is that he adopted something that had been argued often, particularly by scientists.
And Andrew, even though you're talking to Alan, I'm going to ask you to talk to Alan by looking right there, because I think your voice drops down. And I'm worried about the one on the back.
She's the judge, she gets to rule.
I want people to hear you because I know it's important.
And the second is where he notices, recognizes that today you can make use of additional information to pinpoint exact locations. In other words, you may only be able to, using cell phone towers, pinpoint somebody within, I don't know, what, 50 meters, square meters or something like that. But if you have additional information, perhaps from credit cards, perhaps from other types of digital data, you can identify exactly where a person is and what a person is doing 24/7.
And who they're with, who they're meeting with, what they're talking about even.
You correlating it with data concerning other people too. That's what I meant to say.
Totally agree. I think that the legitimate third-party interest, I'll push back on that just a little bit. In Warshak, another Sixth Circuit case, we had a ruling that is essentially treated as de facto law across the country because the Department of Justice follows it, which is that online stored communications are treated essentially as offline paper communications would be treated for the purposes of the Fourth Amendment. So the DOJ doesn't take the position, for example, that they can obtain email records with a mere court order, even though under the statute, under the law, they can. Older than 180 days, email records that have been opened, etc., could be obtained without a warrant under the statute, but the DOJ recognizes that under the Fourth Amendment they couldn't do that. So I think there is, and this is where essentially Justice Kennedy's dissent falls apart, because Justice Kennedy's problem with the majority opinion is that he thinks it either proves too much or it doesn't go as far as it needs to be to support its premise. He says, well, okay, the majority believes that location data is unique, that it's uniquely sensitive, but what about transactional records? What about credit card data, which in theory under United States versus Miller is able to be obtained without a warrant? He says that data is just as sensitive and in fact can be more revealing. And so why doesn't the court?
I have a question.
Yep.
Just wondering, how does this affect the ability of civil litigants or criminal defendants to get similar records, say in a criminal case to defend yourself, where you want to prove an alibi either with respect to your records or you want to prove somebody else did it with respect to getting location records from a provider?
Yeah, that's a very interesting question. I think it kind of is what's animating Justice Alito's dissent, where he's focused a lot on what will the impact be on the use of compulsory process more broadly. And I think I'm not really sure how that's going to work, because I'm not super familiar with how Fourth Amendment issues, if they ever come up in civil discovery anyway. I don't actually know in the civil discovery context how motions to quash a subpoena, for example, or a court order are handled. But I think in a lot of cases, there's probably going to be consent on some level in civil discovery to avoid unnecessary disputes. But that data is certainly sensitive, and to make that data, for example, publicly available would be problematic, I would think, even for someone who's not, subject to criminal enforcement in a civil case. The question about defendants' access is quite interesting, but again, if that information could be obtained under protective order, there may be ways to mitigate. I'm not sure exactly how that gets handled when the individual whose data it is not subject to prosecution. But
Lorraine, you're the computer scientist. Does this case go far enough? Where's the technology taking us?
Well, what I'm happy to see in here from a technology standpoint is a recognition of how much data we carry on our bodies every day. And so the case is very clear in recognizing some of the threats to one's privacy or other rights. And that includes the fact that it's continuously gathering data about your location. It's not where was I at 8 o'clock and where was I at 11 o'clock and where was I at 3 o'clock, but a continuous tracking provides a very precise level of identification and intrusion, if you will. The second thing is recognizing the breadth of the kinds of data that are there. Although this particular case deals primarily with location information, the seizure of the phone is a little bit like going into your home, taking your safe, your financial records, your wills, your letters in your files. And this is what we would consider 20 years ago as being highly intrusive and definitely needing a warrant to justify that level. But it's difficult to imagine our home office and our these kinds of things as being carried around on a daily basis. But essentially, this is what's happening. And so from that standpoint, I think finally being in line with what we know as the power of the data that is available and with you. The other thing I want to mention that Alan discussed is in prior cases, drawing the line between where you are in public space and where you are in private space as a determiner as whether or not you've given up your right and whether or not you have a reasonable expectation of privacy. And again, this sense of ubiquity, and you carry this with you wherever you are. So you're in your bedroom, in your kitchen, in your office, as well as being outside, visible to public and aware of that public visibility. And so that's why this becomes really a highly sensitive data machine that is being given up and highly intrusive in that regard. So that's the point I would make there.
All right. Any comments from the panel regarding this case? And we have a question.
One other thing I want to point out, the limitation of this case, it only applies to cell tower location data. And of course, we are transmitting our GPS data, which is even more sensitive than cell tower data, to entities like Google and other companies where we've turned our location preferences on. This doesn't speak directly, although inferentially, about the ability of the government to obtain those records with a simple subpoena, or to use other technologies like Stingray and others to create a database that mirrors this cell tower location data without a warrant. So there are still gaps in the case and the technology as well.
We have a question. You wouldn't get up for one of the microphones, please.
My question was, I wanted to ask if you might speculate a little bit about how the Carpenter decision might be interpreted or might impact the gathering of evidence or use of evidence in a civil case. I know this is criminal. I know we're dealing with cell phone tower data, which is not available in a criminal case or in a civil case generally. But this is similar to Mr. Grosso's question. What happens if I want to get somebody's cell phone data with all their locational information from another party in a civil action?
Mark, you want to take that?
Yeah, so generally, in a civil action, this would be a third-party subpoena in a civil action, and if the evidence is relevant to the civil action, you're generally entitled to it unless there's some kind of a protective order in place. And so it's really interesting because even highly personal data is subject to subpoena all the time in a civil case. So this was meant to be a restriction on the government under the Fourth Amendment. Fourth Amendment doesn't apply in a civil action because the subpoena is not self-enforcing. And so it effectively becomes a court order ordering a third party to produce records that are relevant to a civil case. So you have this anomalous situation where the government can't get it for law enforcement purposes with a simple subpoena, but may be able to get it in a civil case. The other difference is you get notice and an opportunity to be heard in the civil case.
And I just wanted to comment, and I'm going to be limited in what I say because obviously these issues are coming before courts daily, and they get more intricate and interesting and challenging. But on the last point that Mark made with respect to the civil suit, I think yes, relevant information usually can be obtained and used in that context, but I think the situation he talked about earlier involves perhaps the cell site location information or the data information from a non-party, and that person's privacy interests have to be factored in if they're not a party, third or otherwise, to the case. And so I think it raises some issues for us judges. I know you are a judge, but I think these are the kind of things that we're going to see, and they're going to be a lot of. It's not going to be the just on the one hand, on the other hand balances. Sometimes it's going to be on the one hand, on the other, then on the third and fourth and fifth, because a lot of different interests can be impacted and can be triggered and really brought into this wide net under what we're talking about with cell phones.
One quick question before we move to Loomis. Anybody on the panel have an idea whether this is going to require us to have a national privacy law in order to avoid a distinction between civil and criminal right to evidence?
One quick thing I'll note is on the civil point is that there is actually a law that already protects this information in the civilian context, and that's the under the Communications Act. It's what's called the Consumer Proprietary Network Information, Section 222 of the Communications Act, that actually regulates the providers. So it actually heavily restricts what the providers can do with this type of data in the civil context. So it may speak to that a little bit. As to the privacy law point, I think what this case will do, because there's been a push from organizations like mine and others to establish a national privacy law, a comprehensive privacy law in the United States for many years, decades, is it will change the calculus on the U.S. government side. And all of a sudden, the Department of Justice will want to go to Congress to get more detailed rules about what they can and cannot do to resolve some of these thorny issues. And once the U.S. government is ready to go to Congress and lobby to come up with some bill, then there's, I think, a much higher likelihood that it'll actually make its way through.
All right. We need to move to Loomis. And very briefly, Loomis comes out of the state of Wisconsin, where the Supreme Court ruled on a question as to whether a sentencing court in a criminal case could make use of a report produced by a confidential proprietary algorithm based on a confidential database. And the case did go up to the Supreme Court in terms of a cert request. The cert was denied. The Solicitor General submitted a brief on behalf, at the request of the Supreme Court. It was not heard, but nonetheless is one of the more important cases that has percolated up the ranks in this era of computer technology. I'm going to ask Mark if he can please discuss the case.
Sure. So Loomis involved a sentencing decision by a Wisconsin court for a criminal defendant. And the issue in Loomis was that the state of Wisconsin used two different things to determine whether or not what the appropriate sentence is for any individual defendant. First, they had the normal pre-sentence investigation, which is where the probation officer interviews the defendant and takes into account the factors involving the nature of the crime, the evidence related to the conviction, the ties to the community, and issues a pre-sentence report that describes the defendant. The second thing that they use is they use the same information basically, but use a computer program called Compass. And Compass is a proprietary computer program that was developed for the criminal justice system, not only in Wisconsin, but in a bunch of other states, that uses a predictive algorithm that takes data that relates to not only the defendant themselves, but to other similarly situated defendants, and comes up with a score ranking from 1 to 10 that is intended to predict the defendant's future dangerousness. And based on that prediction of future dangerousness, the judge then sentences the defendant on the two factors. One is the punitive factors, that is, for punishment for the offense for which they committed. And the second one is the preventative or prophylactic factors, that is, to prevent future dangerousness. The higher score you get on the Compass report, the more likely you are to get a longer sentence or more restrictive terms of probation or whatever in the sentence. So Loomis challenged the sentence on due process grounds, on equal protection grounds, on Sixth Amendment right to fair trial. And one of the big challenges that he made was not only to the database and how it worked, but by the fact that the database itself factors that were weighed by the Compass database were all the same kind of factors that you could normally use for sentencing. Things like the severity of the crime and the nature of the crime, criminal history, and the like. There was no way for someone to know how it was weighted and what it weighted against. And he challenged the fact that the database was proprietary, that the algorithm was proprietary, that he couldn't cross-examine for Sixth Amendment purposes the algorithm or the people who created it. And the court in Loomis, and this is the Wisconsin Supreme Court, ruled that those factors did not make the algorithm unreliable, and that he had no constitutional right to challenge the algorithm, and that he had no constitutional right to challenge the use of that algorithm in his sentencing, and affirmed his sentence based on the algorithm. He appealed up to the Supreme Court. Did they originally grant cert, I think, and then denied it, and declined it afterwards? I think that was the case.
No, they did not grant cert.
Okay, so they did not grant cert. One of the big issues was related that Loomis raised in the court below in the trial court was a number of issues related to the algorithm itself. The first one related to the accuracy of the algorithm in accurately predicting future dangerousness, and wanted to introduce evidence that the algorithm itself was not particularly accurate in predicting whether or not an individual defendant was going to be dangerous in the future. Plus the fact that it only used certain amount of data sets in determining whether or not someone was likely to be dangerous in the future. So it only looked at certain categories of data to predict future dangerousness. It didn't look at whole categories. It looked at things like education, criminal history, and the like, but didn't look at other factors in determining future dangerousness. And in fact, one of the problems, and we'll talk about this from a data science standpoint, is that you skew the data by deciding what it is you're going to measure in the first place. So factors that you've already determined are not likely to be relevant for what you're trying to predict. Like if you're trying to predict future dangerousness, you would not measure the color of socks that somebody wears, or the how tall they are, or other factors. So you've already determined in advance what factors you determine are likely to measure future dangerousness, and that skews the end result. So one of the problems was what they were measuring. The second problem was how they were weighting it. The third problem was the fairness or the accuracy. And the final one related to fairness and racial disparity in how it predicted future dangerousness. And he was able to demonstrate that there was a bias in the weighting factor that tended to weight African Americans much more highly as future dangerousness. The other thing is that it weighted things like arrests that didn't result in convictions in determining sentences. And so what happened is you ended up with people who were pervasively being arrested for criminal acts and then being released to charges being dismissed. And the fact that they'd been arrested many times in the past ended up being a factor in determining what sentence they would get imposed in the future. So those are the facts. And really, it relates to a whole bunch of different things that we're doing right now, where we are using computers and computer algorithms to assist the criminal justice function without having the ability to cross-examine those algorithms, to measure them, to weigh them based on open source factors. Now, I will say, on the other end of the spectrum is the human element. So when we do sentencing, whether it's under a sentencing guidelines regime or under a free-form sentencing where the judge is allowed to use any factor that they want, implicit in that is the fact that there's already bias in that as well. There is always the weighting of both appropriate and inappropriate factors. There's both the known biases and the unknown biases as well. So one could argue that the real issue here is not whether it's biased, but whether it's more biased than other forms of sentencing, and whether it's more predictive rather than less. So that's where Loomis stands. What we're going to see is the case was not taken by the Supreme Court, so it remains the law in the state of Wisconsin. The Compass program is being used by multiple other jurisdictions, and we're using other types of programs called predictive policing, so that we will use those tools to decide where we're going to target for law enforcement. And under a predictive policing regime, you will send more police into an area because you predict that there will be crime. Unfortunately, what happens is when you flood a neighborhood with police, they will find more crime, because the nature of crime, the way we measure crime, is based on the number of arrests. So if you flood a neighborhood with police, you end up with more arrests, therefore more crime statistics, and therefore you reinforce your prediction that that area was ripe with crime. And so that's another area where we need really much better understanding of how predictive algorithms work, how algorithms generally work, and how computer science works before we can use this for making decisions as important as sentencing and policing.
All right. We have a question.
Retired Chief of Detectives of the New York City Police Department. Prior to that, I was Deputy Commissioner of Operations, so the Chief of Department and I would run the ComStat process. I just want to correct something. That is, crime is measured by complaints, not by arrests. I believe that is the way it is in New York City. It was the way it is in Nassau County. And so I think that's a very, very important distinction. We deploy, not target, we deploy personnel into areas that have very high crime complaints. So if you have an area where there are a lot of people being murdered, there are not a lot of murder arrests being made because it's a very difficult crime to solve. So I would just like to make a correction on that. We deploy based on crime complaints, not based upon arrests.
I'm going to ask Lorraine to talk about the technology involved, but first, before I do that.
Maybe I didn't understand what he just said, but that seems to be a difference without a distinction, what Mr. Pulaski just referenced with respect to the procedure in New York basing crime on complaints as opposed to arrests. I can't believe anything I've heard so far, but
So let me clarify. If I'm a victim of a crime, I make a complaint. That doesn't mean there's going to be an arrest. The number of arrests versus the number of complaints
If you send a bunch of police
are much less. So
But you
a
make many
complaint
arrests
means a
without there being a
victim.
complaint
An
in the
arrest
first place.
doesn't mean a victim.
Stop. Would you please continue? Mark, we'll be back with you in a moment.
Yeah, okay.
So a complaint is a victim. One arrest can involve 6 complaints, 6 victims. It could be 6 victims in one incident, a robbery of 6 people, or it could be one person who's arrested who committed 6 separate robberies. So there is a huge distinction between complaints and arrests. Police, I feel confident to say, deploy personnel based on crime complaints. I'm now with the Miami Beach PD, and I'm also a member of the International Association of Chiefs of Police. I've been admitted to the New York State Bar since 1981. I have an LLM for what that's worth. I had a lot of fun getting it. That was it. So I'm.
Okay, I want to ask you a quick question. Okay, assuming that there have been complaints, police have been deployed. I think Mark's point referred in part to, let's assume that officers are in the area, officers are on routine patrol, they see what they believe to be a hand-to-hand transaction signaling in their mind, a drug transaction. There's nobody who's called and complained, but certainly there could be an arrest emanating from that if they believe they've witnessed, right, a sale of contraband.
That's right, but the
Okay.
reason they're in the area is because someone's complaining about the sale of contraband.
Okay.
There
All
are
right, I think that's
complaints
what-
that come in.
Right,
So
I think
they-
that's what he was referring to, so I
Well,
think.
I'm glad I was able to clarify it
Thank
because
you.
there's a very significant distinction.
But I do want to point out something, and I prosecuted street crimes in the District of Columbia, and I was with NYPD in the 70s. And there are a couple of ways that those statistics really are, and I do agree that the complaints usually initiate a criminal case. But for example, hand-to-hand sales are much easier to investigate and prosecute when they're done on the street than when they're done, say, in a suburban high school. And so what ends up happening is you'll get more complaints about drug sales on the street in downtown Washington, D.C. than you will in suburban Rockville, Maryland. And therefore, and those are two different jurisdictions, but let's assume that they were the same, you will then have more police presence in downtown Washington, D.C., which results in more arrests in downtown Washington, D.C. And when you look at crime statistics, which are not just complaints but arrests as well, you will see much more arrest activity in an African-American neighborhood in Washington, D.C. because it was targeted than you will in a suburban neighborhood because it's much more difficult to investigate and therefore arrest suburban crimes that are done at suburban high schools. It's just a matter of manpower deployment.
All right, all right.
Well, I think we agree to disagree.
Okay,
Yeah.
fine. Now,
I'd like to agree with that. In all candor, I mean, the reality is, I'm just glad I
well, the real significance of this debate for Loomis is that the owner of the Loomis system, North Point, now known as Equivalent, considers both its algorithm and its database to be proprietary. It uses 137 different factors in order to determine what the chance of recidivism is for an individual. But it won't release how it uses those factors. So if you have somebody in a certain address, say in downtown D.C., being weighted or compared with somebody who is in Montgomery County, you may have a greater calculation of recidivism being possible because coming out of that address, there's more police on the street, there's more complaints, there's more arrests. Gee, he's in a location where by its nature, he's got a greater chance of
Being arrested.
Being arrested because he theoretically committed another crime. Which gets us to the point, what is the significance of Loomis? How do we know whether or not the algorithm is giving accurate results? There was really no challenge on racial discrimination in this case in the Wisconsin courts. There was a challenge on gender because it said that there's a difference in output whether a person is male or female. But there have been studies done of Compass, and they show, among other things, that if a black person who does not commit a crime were incorrectly predicted to do so 44.9% of the time. In other words, there's a 44.9% greater chance of this person committing a crime as calculated by Compass, whereas for whites, the error was only 23.5%. And the reverse is also true. The calculation of somebody not committing a crime was weighted more in favor of the whites than for the blacks. And these were errors that Compass was subjected to. And how do you know whether or not your algorithm is accurate if you can't see it? So there's a real due process question here. And I'm going to turn this over to Lorraine in a moment to tell us about algorithms and databases and the possible biases in both. But before I do, I think I should say Compass stands for Correctional Offender Management Profiling for alternative sanctions. It was designed to be used for correctional facilities, determining whether to put somebody on probation or not and how much supervision to give them, not for sentencing purposes. And finally, the Solicitor General, in urging the court not to take the case, very interestingly, did not say this case isn't worth hearing on the merits. It said this is not the right case to be decided or to be reviewed. That this is an interesting issue. The court may very well want to address it in the future, not for this case. Lorraine?
Did you see you got somebody standing? He's got a quick question.
All right, is it quick?
It's on this point, actually. I
Okay.
was curious because Loomis, the attorney for Loomis, never makes an equal protection argument in the state Supreme Court, and there's good Supreme Court law that says you can't use statistically valid gender factors to discriminate against gender. So I was just curious what the panel's thoughts were to whether or not you can even use gender as an input factor and have it be constitutionally okay.
As a scientist, by the way, I'm a former prosecutor. I was also a grad student in physics and computers. So that having been said, as a scientist, I think the answer is yes. But as a lawyer, I think there has to be some study done and some factual findings by the legislature.
If you're trying to predict recidivism in a rape case, I think gender is a critically important factor.
And you know, the court said that as long that you know, the court had discretion to consider these factors, and I would just note that in this whole area of implicit and unconscious bias, dealing with things like algorithms, you know, you do have, you can have these baked in things, and you know, we as judges are, many of us are generalists. We don't have this background, and the question is, we can rely on this, and so if it's garbage in, then it's going to be garbage out, and the greatest opportunity for disparate bias is where we have the greatest discretion. So we have to be really cognizant, and we have to understand the science. That's all I wanted to say.
Actually, I'm not going to have much to add because I think everybody who's talked so far has pretty
The
much covered the
illusion of
things that I
being
wanted to.
scientific.
But let me, yes, go ahead.
No, speak loudly because.
Thank you. I've got three slides where I want to talk about accuracy, bias, and transparency, and what that means in terms of algorithmic predictions. First of all, as Andrew has indicated, the COMPASS tool is a proprietary instrument that is protected and not available for review by others. The second point about accuracy is to note that, yes, as Judge Donald has said, that it's only as good as the data that you have. And so the accuracy of predicting a result depends upon how good your data is. And in some cases, in certain populations, you may not have enough data to make a strong, reliable prediction. The second is that you may have the wrong kinds of data, and I think that harkens back to the point that was being made about whether or not we're using arrest versus complaint as a metric that's used there, and would that lead to a different decision? Just as an example, I've not seen the algorithm itself, but I do want to mention in terms of accuracy, there was a study done which used that tool and then compared it to actual crimes that were committed 2 years later. And it found that the accuracy of the tool was 60 to 65%, depending upon which element you were predicting. That is slightly better than chance. And so it's really not strong, although from a statistical standpoint, for those of us who do prediction research, when we get a 60 to 65% result on there, we feel pretty good about that, about our ability to predict something. But it's quite different when we're talking about things that have life-changing repercussions. The second thing I want to mention has to do with bias. And yes, there was, Andrew has already mentioned the statistics on the study that was done. We have twice as likely African Americans were predicted to be a high risk, and much less likely whites were predicted to be a high risk, or they were much more likely to be predicted to be a low risk. So certainly there's repercussions for sentencing decisions based upon that bias. The thing about bias, and the reason we're talking about this, is not that we can eliminate bias. Bias is everywhere. It's important to recognize that algorithms are not infallible. We tend to think that things that are built with machine learning that are going to be accurate and are going to get the same result again and again and again are better than human decision makers. But in fact, the studies that have been done also not only on predictive accuracy but on bias have indicated that the decisions that are made by uninformed, unaware, random people is just about as accurate as predicting as a compass tool. So it's not a very good, accurate prediction of what it wants to measure, and that's an issue. The last thing I would mention has to do with transparency, which is what we're talking about here, which has essential relevance to due process. And again, without understanding which data are in there, it's difficult to understand how it applies to a particular individual. Keep in mind, too, all of this from a statistical standpoint is average data about certain groups of population and how an individual ranks within those groupings. It's not necessarily an accurate behavior of an individual, because we all know there are exceptions to the rules and things like that. And so that is an important qualifier to think about when we're talking about statistical predictions and what they mean, the probability that a particular behavior will happen. So I think that's all I have to say on that.
All right. Well, we're going to move on, and we're going to move on to the Bitcoin cases. And there are two of them that I have selected. One is United States against Murgio out of the Southern District of New York that says for the money laundering and transmittal cases of money that Bitcoin is a currency. And then that's out of the Southern District of New York. And then out of the Western District of New York, we have a case, United States against Impetus, which says that for the purposes of the same statutes, Bitcoin is not money, but is an asset. Before we debate the merits of these two decisions, I'm going to ask Lorraine if she can briefly tell us what is Bitcoin. And I'm going to, she has a few charts, and I'm going to move, you want me to do it? Yeah, let me bring up her PowerPoints. Here we go. There's one.
Back up, because I will talk about Bitcoin before I talk about blockchain.
All right.
It's up here.
Here we go. Mark, you're in the way, Mark.
Sorry, I'll do it.
Go ahead.
Okay.
Lorraine, may I say just one thing before we start?
Yes, I'm sorry.
There's a lot of discussion about Bitcoin. There's a lot of discussion about blockchain. And one of the areas of confusion is that Bitcoin is spoken of as being blockchain and vice versa. They are different things, as Lorraine said earlier. Blockchain is the platform for Bitcoin. Well, blockchain is not Bitcoin, and it is something that can be used for a lot of other technologies. Lorraine?
Thank you, Andrew. So I did mention earlier some very simple introductions to what is Bitcoin and what is blockchain. Let me tell you a little bit more about Bitcoin as a form of currency. To be clear, I'm not talking about Bitcoin software, which runs on top of the blockchain platform, but I'm talking about Bitcoin as a form of currency. And whether or not it's relevant and considered money in these particular legal cases. So it's a type of digital currency, so there's no physical property attached to it. But it can be used in exchange for purchasing products, services, and it can even be exchanged for physical currency. But the transactions which share and trade Bitcoins are done on a completely different kind of system than what we know in terms of financial institutions. The impetus behind developing Bitcoin came around in the time when there was significant concern with banking industries and the results of what was happening then. But essentially what Bitcoin, by using the blockchain technology, is done without a middleman, without a financial institution authorizing the transaction and then transmitting the funds to another party. So party A and party B transmit directly to one another, but the authorization and the verification takes place by a collective group in a peer-to-peer network. So the transaction being I'm going to move some Bitcoins from one person to another. They are verified and authorized by this collective group in a distributed network using encryption techniques and a bit of game theory to incentivize these people to do the work for authorizing those transactions. And they're also involved with the regulation of the currency there. So remember I told you that a blockchain was essentially an electronic ledger page. In this particular case, again, to reinforce the concept, blockchain is the technology that underlies Bitcoin, but blockchain platforms can be used for many other purposes. So the transaction between party A and party B is then recorded on a ledger page. And when that ledger page fills up with verified, authenticated transactions, then that entire block gets submitted and chained to the other blocks. And so it's sequential, it's chronological, and it's immutable, meaning you can't break the chains. So a transaction is irreversible. A couple of other properties before I actually show you a little bit more about the blockchain. It's irreversible. It generally is not anonymous but pseudonymous, meaning you do not see a person's name attached. And that is because the blocks are public. The blocks can be read by other parties and participants in that network, but you will not see identifying information because the ID that's attached to that block is protected and hidden. It's fast. All transactions happen within 10 minutes, which facilitates global transactions as well. It reduces your transaction cost, which is very, very important for other developments of blockchain technology. And it also opens up the access of certain populations of individuals who may not have bank accounts. They may not have access to institutions which normally take care of these financial transactions. So there's no gatekeeper involved in the transaction and the transferring of the funds. But blockchain then is the technology. I've already described it, and let me use this visual on here. How well can you see that? Let me see, hold on a second. I'm just trying to make it larger for you to see. And generally, this describes the process by which, I mean, talk a little bit loudly, by which a transaction happens under blockchain technology. In this case, it's Bitcoin, but it could be a transaction of another sort. The ledger page could be other kinds of information. So someone requests a transaction, and then that transaction is broadcast to the peer-to-peer network. So multiple people are invited to authorize, authenticate and verify that the transaction should take place. And there's some encryption involved in there, there's some other kinds of things, but essentially once that is authorized by enough people in that peer-to-peer network, then it becomes a verified transaction and becomes a part of a ledger page. And so once that's verified and that ledger page is filled up, that gets added to the block, which is chained together. Again, remember, in chronological order and linked sequentially, and the transaction is complete. Now that's essentially what happens with blockchain technology. So then it leads to the question of, and again, I lost I lost my transmission over here. It leads to the question of, are blockchain and Bitcoin the same thing? I've lost my transmission there. Can you help me with that? There's Mark again.
Now we've lost all the transmissions.
If you keep going, I can figure it out.
All right.
Just if you keep
Got
talking,
this
I'll figure it out.
It's how I exited out of that screenplay, isn't it?
Mark, can you hear us?
So while they're doing that, let me just ask, how many of you in here are familiar with blockchain technology? Okay, so about half. And Bitcoin and other cryptocurrencies? Okay.
Let me, while they're doing that, let me talk about the cases a little bit.
Yeah, I just want to point out just two aspects of Bitcoin that are relevant to the cases. The first is that Bitcoin has value. Okay, you purchase it with sovereign currency. You can sell it for sovereign currency. You can sell it for products, goods, services, whatever else it is. So there's no doubt that Bitcoin has value, although that value fluctuates. And the second aspect of Bitcoin is that it is not issued by any sovereign. Okay, and so it's not like it's issued by any government, any bank, or anybody else. And so those two things are relevant to the cases that we're going to talk about.
So the two cases, both out of New York, came to opposite conclusions as to whether Bitcoin is or is not, quote, funds for the purposes of the money transmittal statute. That's 18 United States Code, Title 1960. The Mergio Court, where the decision was issued by a district court judge, went to Webster's dictionary to find out what the term money meant. And the answer was funds are available as pecuniary resources. And then the court noted that money is an object used to buy things. Bitcoins are funds within the plain meaning of the statute in that they are used to buy things. And then the court said that it would give a broad interpretation to the terms in the statute because the statute was intended to deal with evolving threats. The IRS, on the other hand, does not treat Bitcoin as a currency, but as an asset. And that has multiple implications, one of which is you buy and sell something using Bitcoin. You have to keep track of what your base was in the currency, in the coin, when you purchased it, and what the value was when you cashed it in and sold it. That has tax implications. It also makes it very difficult to use as a currency because, if I want to buy something using the money in my bank account, it's fairly simple. If I want to buy something using the stock that I hold in IBM, it becomes difficult because not only do I have to figure out how many shares that I have, but I have to figure out, well, when did I buy it? How much did I pay for it? How much am I converting it for? And how long did I hold it so I know whether it's short or long-term capital gains? So the Mergio court, citing that, ignored it and said the fact that the individuals are using Bitcoin in order to conduct business makes it a currency for the purposes of Section 1960. Impetus, on the other hand, reached a different decision. And that decision was issued by a magistrate judge. Impetus himself was arrested for violating his probation. He wasn't supposed to be dealing with computers at all. He had been convicted of a child pornography charge using computers. He was found buying and selling 37 bitcoins for $13,000. Today, 37 bitcoins is worth a lot more than $13,000. And the Impetus court concluded that Bitcoin is a chattel. And it cited as U.S. Supreme Court definition of funds as a, quote, sum of money set aside for a particular purpose. And then found that this Bitcoin is not money as people ordinarily understand the term. It is simply, quote, computer files generated through a ledger system that operates on blockchain technology, unquote. In conclusion, the Impetus court said, maybe someday this will be a currency, but it's not a currency today. Now, if you're wondering about how you advise your clients, can you operate a money transmittal business or a money laundering operation or something else, treating this as not funds or as funds? Mergio has been joined by a number of other district courts, finding that Bitcoin is money for the purpose of the statute. Impetus is an orphan and has not been adopted anywhere else and has been criticized. Nonetheless, the IRS, joined by the Commodities Future Trading Commission, both treat Bitcoin as a commodity or as an asset. So I don't know where it's going to go.
And the SEC treats Bitcoin as a security. So it's treated differently in different contexts for different purposes.
All right. Any questions on that topic? No. Let's move on. We have a little bit of time. Mark, do you want to talk about NOZO?
Yeah. NOZO is a case out of the Ninth Circuit. It's actually two cases out of the Ninth Circuit, and it deals with a fairly simple fact pattern. An employee of a company, in this case Korn Ferry International, left the company and wanted access to a database that the company kept of, this was a recruiting firm, of potential employers and employees. He didn't have access to that database because he no longer worked there, but he went to another employee who had a user ID and password. That employee gave him the user ID and password, and with that user ID and password, he was able to access this database within Korn Ferry and use the database not for Korn Ferry purposes, but for the purposes of this new company that he had set up. So he was prosecuted, among other things, obviously for wire fraud was one of the things he was prosecuted for. He was prosecuted under the Economic Espionage Act, which relates to the theft of trade secrets, but he was also prosecuted under the Computer Fraud and Abuse Act, 18 U.S.C. Section 1030. And the question there was that the Computer Fraud and Abuse Act makes it a crime, among other things, to access a computer without authorization or to exceed the scope of your authorization to access a computer. And the question there became, just like in a trespass statute, authorization to access a computer. The problem, yes.
Mark, we lost you for a moment. Back up with that sentence.
Okay, so the real question there was, what constitutes accessing a computer without authorization, and what constitutes exceeding the scope of your authorization to access a computer? Nosal said that he had a valid user ID, he had a valid password, he was authorized by an employee of the company to access the computer and to access the database. The company, Korn Ferry, said only senior management could have authorized him. And therefore, this raises the question of whether things that are commonly done every day, like sharing passwords, sharing accounts, or giving other people the authorization to use computers or computer resources, violates a federal criminal statute, in this case, the Computer Fraud and Abuse Act. Now, the court in Nosal found that Nosal was convicted. It affirmed the conviction, and it said that he had accessed the computer database in excess of his authorization and affirmed the conviction. There have been a number of cases involving this concept of what are you allowed to do and not allowed to do on a computer, and what constitutes exceeding the authorization to access a computer. One of the more famous ones came out of MIT, in which a researcher at MIT was able to access certain files available in the library and was downloading them and was prosecuted for exceeding the scope of his authorization to access it. That's the Aaron Swartz case. But one of the problems you have here is that, unlike the physical environment, where you have actual lines of demarcation of where you're allowed to be and what you're allowed to do, this concept of exceeding authorized access to a computer, particularly when you're applying the criminal code, is a very difficult one. Now, the original Computer Fraud and Abuse Act did not have a concept of exceeding authorization. It only had unauthorized access, which is in comparison to the real world, breaking in. Now we have the concept not only of unauthorized access that you break in, but also the idea that you do something once you're authorized to be there that the owner of the building or the owner of the computer system doesn't want you to do. So you can have this idea that authorized access, but then you exceed the scope of authorization by doing something that somebody doesn't want you to do. It raises the possibility that, for example, that you're allowed to download, if NoCell had downloaded the same database while he still worked there, but did it with the intent to take that data with him for a new employer, would that have been exceeding the scope of his authorization to access? And so I think a lot of the problems that NoCell brings up are common even to the common law of trespass. So, for example, on the elevated trains in Chicago, you have signs that say no spitting, no gum chewing. Theoretically, if you spit or chew gum on the train, you have now exceeded the scope of your authorization to be on the train, and therefore could be prosecuted not for chewing or spitting, but for trespass. And so that's a real problem we have, that we haven't really adopted the criminal law to that.
Let me say a few things about NoCell. There were two NoCell cases, and Mark has been describing NoCell 2. NoCell 1 was where Mr. NoCell was in the company and was using his password and his account to download information for an improper purpose, to set up his own company. Right. And the court en banc decided, no, he was authorized to do this. As long as he didn't exceed his authority to get on the computer, despite the fact that he had an improper purpose in doing what he did on the computer, does not turn his conduct criminal. In NoCell 2, he was out of the company already, but he was using other people's passwords who were still in the company to do something improper. As Mark said, he did not have the authority to use the password even if somebody gave it to him. Fine line here. The statute with the term unauthorized access is exceedingly dangerous. And I'll give you a concrete example. If Google or Amazon or somebody sets forth in their terms of service or their end user license agreement, thou shalt not do this, and you get on their system and you do it, you conceivably can be prosecuted for exceeding authorized access. So who set the terms of what is authorized and what is not authorized? Did Congress? No. Google, Amazon. These companies now have, in theory, the ability to define what is criminal and what is not criminal.
And by the way, there was a case, Andy, as you're familiar with, there was a case involving a woman who created a fictitious MySpace account and was in the name of a 19-year-old boy, and was prosecuted because she exceeded the scope of the authorization by MySpace, which said that you had to provide accurate information when you created an account. And she was actually prosecuted in Los Angeles for creating a fictitious MySpace account, irrespective of how or why she used it.
In that case, the United States against Drew, Miss Drew lived in Texas. She was prosecuted in Los Angeles because that's where the server was located. She was tried, she was convicted of a misdemeanor, which was then overturned by the judge. It's an area that I think really does need to be addressed as we more and more enter into this area of doing all of our business with other companies on their computers. Any comments? Any questions? One question. NOSAL. Any other? No more questions?
No more questions, but I would just say that, while we've covered the most recent and significant cases, I think that as you can see from the breadth of cases, and there are many we didn't get to involving intellectual property and other things, I think we can see that courts are going to be struggling with these issues because I think law always tends to trail science, yet our rules of law have to be applied to adjudicate these matters, to interpret them, and to prescribe conduct. And it is going to be a challenge that's only, I think, going to get more difficult as we move forward and the technology moves because it goes so fast. And the law does not have that same fast pace. So I just, as a generalist judge, I'm going to be struggling to keep up, but I think we're committed to trying to do that. And sometimes we're gonna get it right, and sometimes you guys are gonna say, "What were they thinking?"
We'll send you good briefs.
Thank you.
All right, I'm going to call it at this one. I thank you all for coming and for the very probative questions that you provided to us. And I want to thank the panelists, Alan, Lorraine, Your Honor, and Mark. Happy birthday.